On May 9, 2022, well-known rapper Young Thug, whose real name is Jeffrey Williams, was indicted in Fulton County, Georgia, under the state's anti-racketeering law. A superseding indictment followed on August 8, 2022. Prosecutors allege that Mr. Williams led a criminal street gang called YSL Young Slime Life, which they claim is tied to his record label, Young Stoner Life, bringing charges including conspiracy, criminal street gang activity, and various gun and drug offenses. The case proceeded to a jury trial before Fulton County Superior Court Chief Judge Euro Glenville on Friday, June 7, 2024. Judge Glenville held one of the state's witnesses in contempt after the witness, despite being granted immunity, invoked the Fifth Amendment and refused to testify. The judge ordered the witness jailed until Monday, June 10th, when the court would revisit his willingness to testify. That morning, Judge Glenville met privately in chambers with Prosecutor Adrian Love, the witness, and the witness's attorney. A court reporter transcribed the meeting, and by its conclusion, the witness agreed to testify. Defense attorneys for Mr. Williams and his co-defendants were not present at this meeting and were not informed it was happening. Under Rule 2.9 of the Georgia Code of Judicial Conduct, judges are prohibited from initiating, permitting, or considering ex parte communications about pending matters, with limited exceptions. After learning of the private meeting from an undisclosed source, defense attorney Brian Steele raised the issue in open court, citing his obligations under the 6th and 14th Amendments to the U.S. Constitution, as well as the Georgia Constitution. Steele stated for the record that the defense was entitled to be present at all critical stages of the proceedings. He noted that the meeting between the judge, the prosecution, and the witness was an ex parte communication and possibly coercive, amounting to witness intimidation. During the exchange, Judge Glenville repeatedly asked Steele how he obtained information about the chamber's meeting. Steele refused to disclose his source, calling it privileged, and emphasized that his duty was to ensure a complete and accurate record for potential appellate review. The judge, visibly frustrated, warned Steele that he could be held in contempt of court if he continued to withhold the source of his information. Steele responded that he did not wish to be held in contempt, but maintained his refusal to reveal his source, asserting that the defense had a constitutional right to be present for any communications that could affect their client's trial. During the hearing, Judge Euro Glenville questioned defense attorney Brian Steele about how he obtained information regarding a private, ex parte meeting that had occurred earlier in chambers between the judge, the prosecution, and a key witness. Judge Glenville: how did you get that information supposedly from my chambers? Did somebody tell you? Mr. Steele refused to disclose his source, citing attorney-client privilege under Rule 1.6 of the Georgia Rules of Professional Conduct, which requires attorneys to maintain the confidentiality of all information gained in the professional relationship, regardless of its source. Judge Glenville countered that the rule allows disclosure when required by a court order and granted Mr. Steele a 5-minute recess, warning him that failure to reveal the source would result in contempt. When proceedings resumed, the judge again pressed for an answer. Judge Glenville: Mr. Steele, before I recessed, I asked you how you got this information. It is not covered by work product. There's only one way you could have gotten it. Please tell me who you got it from. I'm not asking for the content, only the source. Mr. Steele stood firm. Your Honor, with all due respect, I cannot disclose that information. Rule 1.6 applies not merely to communications from my client, but to all information gained in the course of the professional relationship, whatever its source. Disclosing it would violate my ethical duties. The judge disagreed, stating that he was not seeking confidential information, but merely the method by which Mr. Steele obtained knowledge of a private judicial conversation. You can't use privilege to justify obtaining information that wasn't meant for you, Judge Glenville said, calling the matter sacrosanct. Mr. Steele responded that the very reason he raised the issue in court was that such ex parte meetings, particularly involving a witness and the prosecution, should never have taken place without the defense present. It's that serious. "Your Honor," he said. The exchange escalated as both men stood their ground. Judge Glanville insisted that the inquiry did not breach confidentiality, while Mr. Steele maintained that revealing his source would indeed violate Rule 1.6. The judge gave him until 5 p.m. to comply, warning that if he continued to refuse, he would be held in contempt. Mr. Steele again declined, reiterating his belief that the proper remedy was a mistrial due to the improper ex parte communication. When asked once more to identify his source, he answered, "Your Honor, I can't do that under the bar rule." Judge Glanville, visibly frustrated, replied, "Then you will be held in contempt." He speculated that the information could only have come from someone present during the chamber meeting, possibly the prosecutor, the court reporter, or a deputy, and suggested that whoever shared the details with Steele may have themselves violated confidentiality. Mr. Steele maintained his silence. "This is so serious to me, Your Honor," he said. "We need a hearing, and I'm moving for a mistrial." The judge concluded, "Until you tell me how you got that information, you'll remain in custody. I'm not asking for the content, just who told you. You've already given us snippets of what was said, which tells me someone shared that information with you." Mr. Steele did not relent, and Judge Glanville officially held him in contempt of court, ordering him into custody until he revealed his source. As tensions rose in the courtroom, Judge Earl Glanville continued pressing defense attorney Brian Steele for the source of his information about the private ex parte meeting. "Who told you? Who gave you this information?" the judge demanded. Mr. Steele stood his ground, insisting that revealing his source would breach Rule 1.6 of the Georgia Rules of Professional Conduct, which obligates attorneys to protect all client-related information no matter the source. The judge, visibly frustrated, replied, "You can't hide behind Rule 1.6. I'm not asking for the content, just who told you," Mr. Steele countered, arguing that the real issue wasn't how he obtained the information, it was why such a meeting occurred in the first place, outside the presence of the defense. He reminded the court that when a judge speaks privately with a sworn witness, it constitutes a critical stage of the trial, one that requires the defendant's presence. He cited precedent, referring to the 2016 Georgia Supreme Court case, Scudder v. Georgia, which held that defendants generally have a right to be present during all critical parts of their trials. In that case, the defendant's absence was permissible only because the judge had announced the private meeting in open court and no objection had been raised. But in this instance, Judge Glanville's meeting had taken place in secret, with neither the defendants nor their attorneys notified or given a chance to object. Mr. Steele then moved for a mistrial, stating, "Your Honor, this ex parte communication occurred outside of our presence and directly impacted the fairness of these proceedings." Judge Glanville denied the motion, maintaining that the meeting was lawful and procedural. "I had an ex parte conversation," he said firmly. "It was appropriate." The defense disagreed. "You influenced a witness, Your Honor," Mr. Steele argued. "That's a violation of the defendant's constitutional right to be present." The judge dismissed the claim, insisting that the conversation had been proper and that the defense had obtained the information through improper means. "You got something you shouldn't have gotten," he said. "You can't use what was never meant for you and then claim privilege." The courtroom grew tense as the exchange escalated. Mr. Steele refused to back down. "This isn't about privilege, Your Honor. This is about a constitutional violation." He pressed for the release of the transcript from the secret meeting, arguing that it was essential to understanding what had occurred behind closed doors. At that point, Prosecutor Ms. Love addressed the court, defending the state's actions. She explained that the ex parte meeting was held to address a civil contempt issue involving the witness, an issue she claimed was separate from the criminal trial. The defendants had no right to be present, she asserted. This was a civil matter, not a criminal one. However, as Mr. Steele pointed out, the so-called civil matter had directly influenced the criminal proceedings. The witness who was held in contempt had ultimately agreed to testify for the prosecution. After that private meeting, an outcome that undeniably affected the trial's direction, legal experts later noted that while a judge may, in some cases, confer privately on civil contempt issues, doing so, when it materially impacts an ongoing criminal trial, can violate the defendant's right to due process. Ex parte communications, especially those involving witnesses or substantive issues, are strictly prohibited because they undermine the fairness and transparency of the judicial process. In this case, Mr. Steele's argument carried substantial merit. Even if the ex parte meeting was technically about a civil contempt matter, its direct effect on the criminal trial specifically, influencing a key witness to testify for the state, made it a serious breach of the defendant's constitutional rights. After denying multiple motions for mistrial from the other defense attorneys, Judge Earl Glanville turned back to Brian Steele, his tone sharp and final. "Okay, Mr. Steele, last time. Who told you?" When Steele refused once again to reveal his source, the judge's patience snapped. "All right, Mr. Steele's in custody," he declared. Deputies moved forward as the courtroom fell into stunned silence. Steele, standing firm, refused to participate in the proceedings without the issue being addressed. "I will not," he said. "I cannot." The judge shot back. "You don't have that luxury, sir. You don't get to extort the court." Steele calmly replied that he was simply defending his client's constitutional rights. But Judge Glanville pressed on, accusing him of making something out of nothing and violating the sanctity of the court's chambers. Moments later, Steele was taken into custody as his client. Rapper Jeffrey Williams, known to the world as Young Thug, watched helplessly. "Mr. Williams does not wish to proceed without me," Steele protested. "You are removing me against his will, against my will, and you are depriving him of his right to counsel." He asked again for a mistrial, which the judge swiftly denied. That afternoon, after Steele was briefly removed from the courtroom, Judge Glanville allowed him to return. The reason: he didn't want to deprive Mr. Williams of his chosen attorney. But the contempt charge stood. Judge Glanville sentenced Steele to 20 days in jail, to be served on weekends, allowing him to continue defending Williams during the week. In an unusual request, Steele asked to serve his sentence in the same facility where Williams was being held so they could continue preparing the case together. Steele immediately sought appellate relief. Within days, the Georgia Supreme Court intervened, issuing an emergency stay that paused enforcement of the contempt sentence while the matter was under review. Then, in October 2024, the court went even further, reversing the contempt order altogether, holding that Judge Glanville had erred by not recusing himself from a matter in which he was personally involved. As a result, Brian Steele never served a single day of the 20-day sentence. The fallout didn't end there. On July 15, 2024, Fulton County Judge Rachel Cross formally removed Judge Glanville from the entire case following multiple recusal motions filed by defense counsel. Judge Paige Reese Whitaker was assigned to take over the proceedings. Months later, on October 31, 2024, Jeffrey Williams entered a plea agreement pleading guilty to 1 gang charge, 3 drug charges, and to firearm charges, and no contest to an additional gang and racketeering conspiracy count. He received a 40-year sentence, with most of it suspended. His initial 5-year prison term was commuted to time served, followed by 15 years of probation. However, if he violates the terms of his probation, Williams could still face up to 20 years in prison. This dramatic sequence of events revealed something deeper than just a courtroom standoff. It exposed a fundamental tension at the heart of the justice system: the delicate balance between judicial authority and the ethical duties of defense counsel. Judge Glanville acted out of a belief that he was defending the court's integrity and authority. Brian Steele stood firm on his professional obligation under Rule 1.6, the duty to protect client confidentiality at all costs. The collision of these two principles, judicial power versus attorney ethics, turned a trial about gang charges into a national conversation about the rule of law itself. At its core, this case underscored why ex parte communications are so strictly prohibited. Even when nothing overtly improper occurs, private judicial meetings create the appearance of bias and impression that justice may be influenced behind closed doors. The rules exist not just to ensure fairness, but to preserve the public's faith that the system is fair. In the end, this case became more than a courtroom controversy. It became a vivid lesson in accountability, reminding judges, attorneys, and the public alike that justice must not only be done, but be seen to be done. If you found this story insightful, let us know in the comments below which legal showdown or courtroom clash you'd like us to cover next. Don't forget to like, share, and subscribe, because an informed society is a just society.